Hey, Christine Faulkner with Cava&Faulkner, Elk Grove, and Sacramento Living Trust and Estate Lawyer. Thanks for tuning in to another edition of the Daily with Christine. So stay tuned today because you're going to learn whether a California employer can require an employee to take a COVID-19 vaccination. So make sure you stay till the end. There's some great information about how the ADA may apply, the interrelationship between local, state, and federal law, and whether the ADA even applies to your business. So as COVID-19 vaccines become available, many employers are asking, can they require their workforce to take the vaccine in order to continue to work? And what do they do if they refuse? So the EEOC, the federal EEOC, weighed in on this on December 16th, 2020, with new guidance about and answers some workplace vaccination questions. Employers may encourage or possibly require COVID-19 vaccinations, but the policies have to comply with the Americans with Disabilities Act, or the ADA. Title VII of the Civil Rights Act of 1964 on the workplace and other workplace laws, according to the EEOC. So let's talk about number one. What does the ADA, who is falls under the ADA? So Title I of the ADA applies to private employers with 15 or more employees. So obviously, if you are a very small business and you don't have more than 15 employees, the ADA doesn't apply to you. It also applies to state and local government employers, employment agencies, and labor unions. So that's a really important question. Do I even have to comply with the ADA? If an employee refuses to obtain a vaccine, an employer needs to evaluate the risk that the objection to take the vaccine poses, particularly if an employer is mandating that employees receive the vaccine. Under the Americans with Disabilities Act, an employer can have a workplace policy that includes a requirement that an individual shall not pose a direct threat to the health or safety of individuals in the workplace. If a vaccination requirement screens out a worker with a disability, however, the employer must show that the unvaccinated employee would pose a direct threat due to a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by a reasonable accommodation. So anybody who's familiar with the ADA knows those words, reasonable accommodation. So here are 4 factors that employers should evaluate to determine whether a direct threat exists. Number 1, the duration of the risk. Number 2, the nature and severity of the potential harm. Number 3, the likelihood that the potential harm will in fact occur. And number 4, the imminence of the potential harm. If an employee who can't be vaccinated poses a direct threat to the workplace, the employer must then consider a reasonable accommodation if that can be made, such as allowing an employee to work remotely or take a leave of absence. So, number 1, you have to determine, is there a direct threat? And obviously, that's going to require some investigation by the employer to determine, well, what would the duration of the risk be? What is the duration of the risk if the employee doesn't get a vaccination? The nature and severity of the potential harm. And so I can imagine that might look like an employer looking at the other people in the workforce to determine, well, what are their ages? What do comorbid conditions do they have? And you may not even know as an employer, or you might know that you have a compromised individual in your employ. And so allowing another individual not to get a vaccination might have a greater impact in your particular workplace because you have an immunocompromised employee who would be directly impacted, and there would be a much higher risk of potential harm to that other coworker. The likelihood that the potential harm would occur, that might be a pretty difficult assessment. Balancing to do some research on what is the likelihood of folks in your employment contracting COVID if an individual chose not to get vaccinated. And again, that probably depends on the demographics of your employees, as well as the imminence of the potential harm. So you're going to have to weigh all of those factors in determining, number one, if there even is a direct threat. And then if there is, you go to the next step of determining, again, under the ADA, whether a reasonable accommodation can be made. And so reasonable accommodation is generally viewed in the totality of the circumstances. And so allowing someone to work at home after the pandemic is probably going to be a lot easier to allow than perhaps pre-pandemic. And that consideration about whether that is a viable option as a reasonable accommodation depends on your workforce. How many people do you have employed? The larger your operation, the more likely that would be considered an easy accommodation to allow. If you're a very small operation and historically you have not allowed people to work from home because they need to be there in the workspace, and you are a small operation, you don't have a backup if someone is not there to handle the work in person, you're going to have a better likelihood of prevailing on the argument that working from home might cause an unreasonable disruption. You're not required under the ADA to actually hire somebody to replace that person and then also keep them on the payroll. So the smaller your operation is, the more likely you are to prevail on the inability to allow someone to work at home as a reasonable accommodation, because you don't have sufficient management to oversee those folks, whatever your situation may be. But just know that the larger your operation, generally the easier it is to accommodate individual employees with a, quote, reasonable accommodation, whatever that may be. And in this case, it may be working from home, or it may be perhaps segregating that person in a different workspace. Not sure, how that would work and whether that's even doable for many employers. Employers and employees do have to work together to determine whether such accommodation can be made. Employers should also evaluate the employee's job functions, whether there's an alternative job that the employee could be placed into that is going to make the vaccination less critical, and how important it is to the employer's operation that the employee be vaccinated. There is an exception for religious beliefs. So Title VII requires an employer to accommodate an employee's sincerely held religious belief, practice, or observation, unless it would cause undue hardship in the business. Courts have said that undue hardship is created by an accommodation that has more than a de minimis or very small cost or burden to the employer. The definition of a religion is quite broad, so I'd be very careful. Even if someone is not part of a traditional religious organization, there is a fair likelihood that whatever their religious beliefs will be considered to be part of a religion. An employer should ordinarily assume that the request for religious accommodation is based upon a sincerely held religious belief. If an employee can't get vaccinated because of a disability or sincerely held religious belief, and there's no reasonable accommodation, an employer can exclude the employee from physically entering the workplace. This doesn't mean, however, that the individual is automatically terminated, and you'll need to look at both federal and state laws to determine your next step. Probably the safest step for employers to take at this point is to encourage their employees to get vaccinated. And if it's important in your business that you want to require vaccinations, that you develop a written policy requiring that people are conducting themselves so as not to pose a direct threat to the workplace. So rather than implementing mandates that could lead to difficult decisions, employers may wish to focus on steps they can take to encourage and incentivize employees to get vaccinated. And employers may want to do a number of different things, including number one, develop vaccination education campaigns. Number two, make obtaining a vaccine as easy as possible for employees. Cover the costs which might be associated with getting a vaccine, which we know right now there is no cost to getting the vaccine itself. Providing incentives to employees who do get vaccinated and providing paid time off to get the vaccine and recover from any potential side effects. So certainly employees who experience side effects, and I know we've been hearing more recently that people have had some greater side effects than originally thought, or a greater proportion of folks are getting side effects. If you are indeed encouraging your employees to get the vaccine and they actually go get the vaccine, you may want to rethink your leave policy to allow folks to recover for a day or two, or even a week, depending on the severity of their symptoms, if they do indeed get a vaccine, as an incentive to encourage people to be healthy. So just a couple of ideas on what you can do to both encourage employees and how you can take steps to document necessary procedures if you plan to require your employees to get the vaccine, and perhaps a little clearer picture under what circumstances you might evaluate whether a person refusing to get a vaccine is a direct threat, and what type of accommodation you may have to look into, and the analysis that goes into determining what type of reasonable accommodation may be necessary given your specific circumstances under both federal and state law. Thanks again for tuning in to The Daily with Christine. Subscribe to our channel if you like our content, and let us know how we can help you. Like our video if you like this content, and let us know what we can provide for you, and we'll be happy to provide even greater content. Thank you so much. See you next time. Bye-bye.